Good morning. Can everybody hear me?
Good morning.
Okay.
Morning, I can hear you.
Welcome to a Law Day oral argument Zoom session for the 5th District Court of Appeal. Because it is a Law Day session, we have Barry Law School, as I understand it, is watching this Zoom session. And after our two cases today, the panel will join Barry Law School in a separate Zoom session for Law Day. So we look forward to that. With that, our first case today is LaPera versus State. Oh, let me introduce the panel. Forgive me. We have today Judge Molly Nardella with us on the panel. And then we have a visiting judge, Chad Alvaro from Orange County. Judge, thanks for joining us as an associate judge today. So first up on the docket, we have LaPera versus State 1965. And for appellant's counsel, if you would just let us know how much time you'd like in rebuttal, I'll do my best to remind you when we get there, but you need to watch the clock as well in case I miss it.
Yes, sir. 5 minutes would be great.
All right, so 5 minutes. I'll do my best to help you watch that. And counsel for the appellant, you may proceed whenever you are ready.
Thank you, Your Honors. May it please the court, my name is Dean Bartsokis, and I represent Gregory LaPera. The following appeal follows a boating crash that occurred May 12th, 2012, and a trial that occurred April 29th, 2019, that was completed on May 8th, 2019. There is also some issues that we put in the appeal following regarding the sentencing.
Counsel, your expert, Dr. Liu, am I saying her name correct?
Right.
Reading the proffer of her testimony, and I understand it would have probably been longer and a little bit more in detail had it not just been a proffer, but I sort of understood what her expert opinion was, what it was and what it was based on for the deceased position in the boat, things of that nature. I was not at all clear on what her opinion was as to the other occupants.
Right. I don't believe she formed an opinion with regard to Ms. Walker because Ms. Walker didn't have any injuries, but she did form an opinion with regard to Mr. LaPera. Mr. LaPera, she said, most likely had his head injured on the back panel of the boat, which followed at least our case theory that Mr. LaPera was in the passenger seat facing the starboard side, and he was launched forward. And then once Miss Walker did a panic acceleration, he was launched into the back of the boat, striking his head on that panel, and that's where his blood was found.
Striking his forehead on the panel?
Correct, and that's where his blood was found in that region, Judge.
Her opinion was that he, quote, moved horizontally, or his movement was horizontal. I'm not entirely clear. I'm not sure that I'm clear on what, sort of what the significance was to your theory of defense, that particular opinion. Can you elaborate on that?
Right. Well, what the state was claiming in their opinion was that Mr. LaPera was seated in the driver's seat and was launched forward by the impact, striking his head on the damaged glass panel, for lack of a better word. I don't know boats too well.
The windshield.
Right, windshield, exactly. And at least our expert was testifying that since the side of the boat struck the staircase first, which the state didn't have at least a position on, that he was launched horizontally, and then due to the panic acceleration was launched to the back of the boat. So if he was launched horizontally, he wouldn't hit the windshield. As
opposed to vertical, which would be going up.
Correct, Your Honor.
Okay. And your position is that those expert opinions confirm the opinions that were presented to the jury of expert Stewart?
Right. Well, they don't just confirm, they confirm and supplement, I would say. With regard to Christopher Stewart, he was obviously limited as just an accident reconstructionist discussing physics. And so he's discussing where they're physically going due to, I guess, physical evidence, damage to the dock, damage to the boat, damage to the staircase and the handrail. but Dr. Liu supplemented that with her injury mechanism analysis. So she was going to testify that the state's case theory that he was launched off the boat and struck his head on, I guess it was pylon A, could not have happened that way. And that he would have actually, the damage more likely would have come from the sonar mount, which was right by the windshield, essentially. And where
That
he
was
collapsed
based
the windshield.
upon the measurement between the injuries, the angle of the injuries, things of that nature.
Correct, Your Honor.
Okay, go ahead, counsel.
Yes, Judge. And with regard to, I guess, the importance of Dr. Liu, without being repetitive, is our importance, at least, is she's going to show that not only these injuries were consistent with Christopher Stewart and supplement his findings, essentially, and I guess add to his findings, but with regard to, I guess, the state's case theory didn't make any sense. So that would have supplemented our reasonable doubt argument, because Christopher Stewart saying there's no way Mr. Kadzierski, the deceased, could have launched off the boat with the other occupants not launching off the boat. That's not how physics work. And then Dr. Liu essentially saying that those nails could have never caused that damage, including things like Christopher Stewart saying that if the deceased was launched off the boat, why was his belt buckle found inside the boat toward the front of the boat? And why was his blood found actually in the back of the boat if he just immediately launched out? None of that makes any sense. And
I had a question. I mean, I think you've established that the testimonies of Mr. Stewart and Dr. Liu maybe overlap a little, but that Dr. Liu's testimony is separate and apart. It adds something else, right? So let's assume you're right, and the testimonies of those two experts were not cumulative under Gutierrez and Vargas, so on and so forth. So let's assume that testimony of Dr. Liu should have come in. My question goes to harmless error. Doesn't it have to be proved beyond a reasonable doubt that the error did not contribute to the conviction? And another way of saying that is, don't you have to show that the only reason the jury convicted was that it didn't hear Dr. Liu's testimony?
Well, my understanding of harmless error, and I might just be repeating what you said, Your Honor, is that once it's shown that there was error, it's the state's position to show that it was harmless beyond a reasonable doubt. So our position is that it is harmful, because the only testimony, well, at least Kevin McKinney said he based his arrest on Mr. LaPera's admission, and that admission was partially, I don't remember anything. Okay. And there was ample evidence that he didn't remember anything and he had retrograde amnesia.
Are you talking about the incident report?
Yeah, well, his testimony too, Judge.
Okay.
Yes. And he also testified that he based it on the admission, Emily Walker's testimony, and the fact that it was Mr. LaPera's boat. So, I mean, those are very limited things that we, I think, quite easily rebutted with, especially with our expert witnesses. So I do believe it's harmless, because all you have right now is Emily Walker, who was a highly impeached witness, who constantly altered her story, and who
That's not all you have, is it? I mean, you still have the admission itself, right?
Well, the admission
him.
I'm sorry, Your Honor, what was that?
Go ahead. What did you say?
Right, Judge. The admission was coupled with, I think, I don't remember the exact quote, but it was something like, I killed my friend. I don't remember anything. And Kevin McKinney on scene, who's the one that heard the witness that was non-recorded, unlike Emily Walker's statement that was recorded. Kevin McKinney, the Fish and Wildlife officer, stated that Mr. LaPera stated that he did not remember. So
he said more than once, according to the investigator, I was driving, I killed my friend. And then at one point, I'm trying to find it in the record, I'm having some difficulty, but at one point he says, I guess I was driving, right?
Right.
Which is a little bit more equivocal. So, and then at some point, I don't remember him saying, and I'll find it, but I don't remember him saying, I don't remember anything. I think he said, I don't remember what happened, or I don't know what happened.
Well, at the record on page 73, it's the incident summary report says, I killed my friend. I must have, because I was driving, I killed him. Was that testimony, was that introduced at trial?
Well, the testimony, and it's in the initial brief, Judge, is he had to be, his reflection had to be refreshed at least 2 or 3 times in the same line of questioning as to what he said. His same report had to be shown, because I think the first thing he said in testimony was, I killed my friend. I must have, because I was driving, or something to that effect. And then Mr. Stone keeps refreshing his recollection, and then he has the whole statement later on in the statement of facts, Your Honor, where
it's in the transcript at 8:29. He says, so this is at trial, if I'm looking at the correct part of the record, at 8:29, the transcript. On cross-examination, the investigator concedes that your client also said, I guess I was driving, I can't remember.
Correct.
And then there was another statement, also the bottom of 8:29, where the investigator conceded that your client said, I can't remember anything. So I guess the question there is, what does I can't remember anything mean?
Well,
How broad is that?
Right. Well, I think that, coupled with Dr. Willie's testimony that he suffered a concussion, he had retrograde amnesia of the event, at least explains our portion that Mr. LaPera truly couldn't remember anything. And obviously, maybe not totally relevant here, but in the sentencing, when he was obviously extremely emotional and sorry because it was his friend that was killed, he testified again. He said, I'm sorry, I could not remember anything. So obviously we're talking after the trial at that point, but I do think there is credence to the point that he had amnesia of the event and could not remember anything.
I mean, at minimum, I think it's fair to say that if you look at all of the statements sort of comprehensively, that they were at least somewhat equivocal.
Yeah, that's fine. I'm not disputing that, Judge. It's, again, that statement, which again had an explanation. I think if he didn't say, I don't remember anything, or I can't remember, then I think we have more of a problem. But I do think, since all those statements are coupled into one, that Emily Walker is the case, at least for the state. And obviously, with Emily Walker being that important, that couples with a multitude of different things that are argued in the brief. With regard to, I think the next thing to jump to would be the jury instruction that we requested, the special jury instruction, and that specific instruction.
Can you talk about the credibility issues with Walker first?
Right. I think there was a couple things that we pointed out. One was, after the accident, she gives a statement. That statement that she gives is very emotional. Before the statement's given, she asked the police to call Shannon Seipel to the scene. I'm more
referring to the potential character evidence and things of that nature that didn't come in.
With regard to
you've raised in your brief.
Right. Okay. I understand. I'm sorry. Yeah, I think you're talking about issue 5. With regard to Debbie Holt and Mr. Etheridge, I think Mr. Etheridge, I do think we conceded that the reputation testimony of his was not general enough. However, he was going to testify that Miss Walker told him that Jimmy saved her life and pushed her down, which went in line with our case theory that Jimmy was not launched off of the boat. He actually was thrown over the front of the windshield, shielding her from being harmed. And that's why she had no injuries. So
How does that speak to reputation for truthfulness in the community? I thought that was kind of the thrust of this issue.
For Debbie Holt, it was because she did testify more for reputation in the community. She testified, I think the judge ruled that it was too remote in time. But our position is that since she had knowledge of her reputation in the community at the point where she was making initial statements to police, initial statements to other individuals, that we should have been able to use that as impeachment regarding her character and lack of truthfulness. And I think it was limited to, the judge was just saying that we couldn't introduce it at all, but we weren't attempting to necessarily introduce it, that she was lying on the stand on that day and that she had a reputation for untruthfulness on that day. It was more when the statements actually occurred and when it was relevant with what she was telling police at that time. Miss Holt had authority to give a reputation evidence and reputation information at that point in time. And additionally, with regard to Mr. Etheridge, I mean, I think those statements are absolutely critical, where she says, Jimmy saved my life. I mean, if her position is that the accident occurred and Jimmy's gone immediately and flew off the boat, how could he have possibly saved her life? So I think that is critical impeachment evidence that we were not allowed to present. Now, going to, and I'm trying to focus on
the jury instruction, counsel.
Yes, the jury instruction. I think an important issue is with regard to overbreath and vagueness, and I'll start with overbreath since I don't believe there's a standing issue on that the state had raised. I think the real problem with this statute is applied to Mr. LaPera and applied to other individuals is if Emily Walker gets off that boat and she admits, I was driving, I was behind the wheel, technically the police under the statute, the way it's written, can arrest both these individuals for boating under the influence manslaughter, is that the argument can be that Mr. LaPera was responsible. And that those are the two issues we have, the responsibility and the in charge of. I mean, there's an endless amount of people. And I think the Colasia case discusses use being unconstitutionally overbroad. But in this particular case, when that's a real problem.
Why would it be overbroad to say, well, if Ms. Walker was actually at the wheel, but your client was directing her and essentially the captain of the ship telling her where to go and what to do, why would that be overbroad, counsel?
Right. And I mean, obviously those are missing facts, but I mean, I understand the court's position. I still think the designated driver portion in that statute causes a ton of confusion, and that's obviously more of a vagueness notice issue. But when you have a section that says we're encouraging boaters to designate a driver, and our position in this case is that Mr. LaPera did exactly that and designated a driver. I mean, this is creating a ton of confusion for boaters everywhere. I mean, for small boaters, they would essentially never be able to get on a boat and have an alcoholic beverage. And that's fine if the legislature wants to do that, but why would they put subsection 10 in there if they're trying to encourage designated drivers? I mean, I think it causes a pretty big issue.
You're into your rebuttal time. Do you want to save it?
Yes, Judge, can I save it, please?
Sure. So you'll have about 4.5 minutes there in rebuttal. And with that, counsel for the state.
Yes, Your Honor. May it please the court, my name is Pam Kohler. I represent the state of Florida. As far as the first claim.
Counsel, if I could, first, before we get into that, I couldn't help but notice your answer brief very much appears to be 1.5 space. The lines are 1.5 space instead of double space. Why is that?
I used Times New Roman and it's two spaces.
2 spaces between the lines?
Yes, sir. I would never.
I use Times New Roman all the time. It doesn't appear at all to be 2 spaces.
I can show you the metadata if you want.
Rule 9.210 requires double spaces. So just please be cautious about that. Your brief was 55 pages as it was, which is fine because we granted leave to do that. But please in the future, make sure it's double spaced.
I have never filed a brief that was not double spaced, Your Honor.
Go ahead with your argument, counsel.
And I've been doing this for over 20 years. Sure. As far as number one, I would submit that they couldn't even show harmless error in this case. Number one, most of her testimony would have been cumulative to Christopher Stewart's testimony.
How would it have been cumulative, counsel? Explain. I think that I'm not sure I'm following your argument on that.
Well, to the extent that she was going to testify that the victim was standing in the middle of the boat, that the defendant was sitting in the passenger seat, and Emily Walker.
Those are conclusions that these two different experts reached, and they reached the same conclusion. I don't think that makes it necessarily cumulative.
Well, she also admitted that she's relying on his work, basically work product, in reaching that conclusion. But to the extent that it was not, to the extent that she was offering causation of injuries, what the judge did not allow because she was not a medical doctor, even assuming that's harmless error, or that it's error, it certainly was harmless error beyond a reasonable doubt. They rely on the counsel case. But in the counsel case, the defense could not even argue that it was an accidental death, that it was accidental injuries. In that case, it was a shaken baby case, and the judge refused to allow the expert to testify as to causation of injuries. And they found that that would have been the only way that the defense would have presented any evidence that it had been accidental death, accidental injuries. Whereas here, they could obviously argue that, the defendant was sitting in the passenger seat, the victim was in the center, and the Emily Walker was to the left.
Well, they could argue, counsel, but I mean, the prosecutor below, I mean, really went after the one expert Stewart, went after his testimony, went after his conclusions, said they were wrong. You know, I mean, the entire case was sort of, it's, you know, largely on, hey, was expert Stewart's, you know, theory on this credible? Was it correct? You know, it seems difficult when you have another expert who, based on different facts in a different sort of area of expertise, says, yeah, I looked at slightly different things, different facts, and I reached the same conclusion. How can we say that's harmless beyond a reasonable doubt?
Because to be honest, it really doesn't matter. I mean, even if it happened the way that the defense was saying it happened, there's no way, as the state argued, there was no way. Number one, it doesn't make any sense because, you know, the defendant had all these injuries based on, you know, clearly the windshield bent forward. He had injuries to his face. He was bleeding down the front of him. His blood was found on the steering wheel and the seat, the driver's seat. The victim's blood was found in the back of the vehicle.
He drove the boat after the collision, right? He parked the boat while he was bleeding. Isn't that right?
That was his version, but he's bleeding like this and somehow it's getting on the seat. And, you know, maybe I guess it could get on the steering wheel, but it gets down on the seat somehow and he's driving it in. And, you know, no one, as you know, even if he was operating this vehicle.
Didn't the defense through their at least through their experts offer an explanation for all of that? Now, it's up to the jury to decide which to believe, but didn't they explain all of that?
They tried to, certainly. They also, you know, they argued that there's no way that the victim struck pylon A and the two bolts, but the victim's blood was found high up on pylon A. So that was one of the things the state pointed out, that, you know, their version of events didn't make any sense, that this expert was wrong, because by the way, the victim's blood was on pylon A, and they said there's no way the victim struck pylon A. So, I mean, the arguments that the state made were based on the evidence at the trial, the state's evidence that refuted the expert's claims, and therefore, you know, it wouldn't have helped to have another expert come in and just basically double down on this, that it still would have been wrong. The idea that the victim somehow covered up Miss Walker as he was leaving the vessel didn't make any sense either. As I recall, he didn't have a lot of injuries to his back. And the idea that only because that one person stood up, that therefore that they all would have flown out if they all had been seating and one flew out. Maybe the victim stood up when they were about to hit, you know, the pilings and wanted to stop it. We don't know what happened. Unfortunately, one person's dead.
Wouldn't those be arguments for the jury though?
Absolutely. But the bottom line is this testimony would not have changed the outcome of this trial. The defendant's, blood was in the steering wheel, on the seat. He was injured to his face, which would be consistent with being in front of the windshield when it bent back. His blood was not back there. The victim's blood was back in the back of the boat. The victim's blood was on the pylon. So the idea that somehow that this would have changed anything. Also, even if he had been sitting up front in the passenger seat rather than steering the vehicle or the vessel, there's no way that he would have just turned over his boat completely to Ms. Walker. And I mean, she had never been on that boat before. She'd never been on that lake before. It was pitch black out. She said she didn't think that the defendant was under the influence. And, you know, he's the one who backed it out. They were going across the lake to look at some property. And so, it's kind of silly to have her driving if they're wanting to look at their property. So they pull up against the property. She said, luckily she changed.
This was essentially, the state's evidence was Walker and the investigator, right? No expert.
Well, and the blood.
Right. But that doesn't, the issue here is who was driving.
Right.
The issue I'm talking about is who was driving. I mean, as far as that issue goes, right, it's Walker and the investigator, right? That's really, mostly. Anything else of significance?
Well, and the defendant's own statements afterwards that I must have been driving.
The equivocal statements afterwards.
Well, he said, I must have been driving. He didn't say, I don't remember.
I guess I was driving. I don't remember.
Sure.
The investigator admitted that's what he said.
Sure.
Right.
Right.
So the equivocal statements while he's either intoxicated or has right after an accident. Then Walker's statements that he was driving and not her.
And her lack of injuries to her face. I mean, the only injury she had was to her hand where she admitted trying to hit the throttle.
If the victim was sitting in the back with Walker upon impact, why would the victim be ejected but not Walker?
Well, of course, she was a lot smaller, and she talked about somehow she ended up, in back of the seat in front of her. So, I mean, he was she was like 5'2". She was very petite. The victim was 5'8" or something like that, and about 200 and some pounds. I mean, he was a big guy. She talked about how when he stood up to try and to look at the boat started rocking away right away. So he sat down, and that's when he moved her over to the other side so he could be closer to the shore. So I think that the fact that he's taller, and again, like maybe he saw something happening, he stood up and tried to.
Counsel, you didn't present. I mean, the state didn't present any expert testimony here. I mean, this is speculation by lay people, correct? I mean,
sure. Well, it was by the investigator as well. I mean, the investigator never argued that he stood up, but I mean, clearly at some way, we don't know why. I mean, even Emily Walker. My point is the state didn't present any competent evidence to explain why, if they were both sitting in the back, one was ejected and the other wasn't. And by the way, one died and the other had virtually no injuries. The state didn't present any competent evidence to explain that, correct? I don't think that they did, other than, the fact that, I mean, obviously the victim was a lot bigger. And again, we don't know what happened. I mean, that's the problem, is Emily Walker didn't really know what happened because she was sitting in the back. She said she was just looking up at the sky when everything hit. And by the way, that was one of the statements she had made to her ex-husband, that they wanted to, they were talking about wanting to get in. So the other one had to do with the fact that she had said that he covered her and protected her. And the defense did get to actually question her about that on cross-examination, asked if she had ever told her ex-husband if her boyfriend, her fiance, had saved her. And she said, no, I never really said that. What I did say was how bad I felt that because we had switched places, that he ended up dying, and I would have ended up dying if only, if I'd been sitting in that seat.
Ms. Kohler, I want to ask you about the reputation evidence that would have been offered by Mrs. Holt. If Mrs. Holt had been able to testify at the time of trial that she was still going to boot camp in the salon, that she was still riding motorcycles with the same community as Mrs. Walker, would her testimony have been admissible? Well, she didn't. I mean, obviously then it would have been relevant, because it would have been relevant to her testimony at trial. Whether or not that would have been a large enough community. She admitted that the primary reason she believed that she was not honest was because of her criticizing Jimmy when they went to try on dresses. And she said she was very shocked about that and basically disassociated herself from her ever after that. But if I understand, you guys have a temporal problem with her testimony, and I understand that. But correct. You have a problem with the breadth of her community. I believe she testified it was 20, 25, or 30 people that they had in common. Does the state have a problem with the community not being large enough? I think, as I call it down below, the state only objected as far as the timing of it, the timeliness of it, that it was essentially no longer valid or relevant because she hadn't had anything to do with her for years. What do you say to counsel's argument that, look, it was relevant when she made the statements on the night of the accident? Well, but the problem was that wasn't relevant either. I mean, they challenged that, and they could always challenge that statement. And in fact, they actually relied on a great deal of that statement their expert did in recreating the vessel, crash. So I think that's why they didn't want to go and attack her at the time that she made that statement, because they were relying on it. So much of it, as far as they weren't relying on her statement that when she said that she wasn't driving. Correct, but they were relying on some of the others, but the majority of it they did. Let's be honest, that's the most important statement here, right? I mean, the key to this case is who is driving, right, counsel? Well, again, Emily Walker did not testify that the defendant was driving at the time of the crash. She says she basically was looking up, so she could not testify and never said that's who was driving at the time. It's just that she knew she and Jimmy weren't doing it. So obviously the defendant had to be. And again, even if the defendant was sitting in the passenger seat and she was there in the driver's seat, she didn't know that lake. She didn't know that boat. It was pitch black outside. Clearly the defendant would have been navigating.
Counsel, we're talking about the testimony, the potential testimony regarding her reputation, right?
Sure.
And so I guess the question is, one of the witnesses, I can't remember which one, said that they did know her reputation for honesty at the time of the crash, and that they knew it because they spoke to 20 to 30 people. Why is that not relevant?
Well, of course, another problem is, of course, Denise Holt was the girlfriend of the defendant, as I recall. So, for the fact that she'd come in and testify against Emily Walker would hardly be as credible as somebody else who barely knew her, who wasn't the defendant's girlfriend. So I would submit that, to be honest, even if she had come in and testified, there would not have been any kind of, impact, certainly when it changed the outcome.
Well, that would only go to her credibility in rendering the testimony, not whether or not the testimony itself is admissible, right?
Sure, but I'm also going to any sort of harmless error argument, assuming that you're going to find that she should have been allowed to testify. I would submit it would not have made a difference because she was the girlfriend of the defendant. Clearly, she's going to testify, oh no, she's a complete liar at the time and now. That's clearly what she would want to testify to.
And that obviously that goes to a sort of a harmless error analysis is what you're
Correct.
saying. Correct.
Right. Absolutely. Right. As moving on to the jury instruction, again, the jury instruction follows the statute precisely. It's not that like mere presence in the boat meant that he was the operator. They had to show more than that. They had to show that he was in charge of, in command of, or in actual physical control, to exercise control over, or to have responsibility for a vessel's navigation or safety while the vessel is underway. And the idea that he would just completely turn over control to Emily Walker, who'd never been on that boat, didn't have much experience with navigating boats, had never been on that lake before. It was pitch black because it was probably 1 o'clock in the morning. Just did not make any sense. And
isn't the main issue the arguments made in closing by the state attorney, where he goes, I have a duty to tell you that even if you don't believe the defendant is the driver, you can still find the defendant guilty because he's responsible. He's on the boat, he's the owner, and there's some lighting issue.
No, that's not just what the state argued. Absolutely not. The state did not just say he's the owner and he's on the boat, therefore he's guilty. The state said, look at all the facts. Look at the fact that, like I was saying, Emily Walker had never been on that boat before. Emily Walker had never been on that lake before. Emily Walker, was a guest, and it was pitch black that night. And that there's no way that this defendant would have just said, oh, sure, take over the boat, completely. You don't know where you're going. You don't know where we're at, but just go ahead and take over the boat completely.
Ms. Kohler, does that go to the credibility of whether or not Emily was actually driving? Like, how believable is it that Ms. Walker was actually driving for all of these reasons? It's his boat, it's his lake. He knows how it works. Or does that go to his responsibility as a passenger on the boat? I guess that's where I'm having a question.
No, I think it goes more to the likelihood that he would have just been a passenger on his own boat. Maybe if it had been in the middle of the day and you could see everything, it was easy to navigate, and she wanted to try it out. She went into the boat and she decided to drive. But this is the middle of the night. It's pitch black. She doesn't know where she's at. She doesn't know where she's going. She's never driven that boat before. The defendant had that boat for over 10 years, had lived on that lake for over 10 years. Who's more likely to be navigating and in control of that vessel? I think that goes to just as the state kept saying, common sense that, she would not have just totally been able to take over control of that vessel that night. Maybe in a different time with different circumstances. Yes.
Those are a lot of inferences, counsel. Is that, at what point do we just sort of hit speculation?
Well, again, I mean, we have to prove it beyond a reasonable doubt, and rebut this, but the fact, there was a lot of evidence that the state presented as far as that Christopher Stewart's testimony was not reliable, as far as like with the pylons, and that sort of thing. And the idea that somehow he had covered her up and that's why she didn't have any injuries. But
doesn't that make Dr. Liu's testimony even more important? Because she really seemed to zero in on, hey, look, these injuries, given their size and the dimensions and the angle, these injuries had to have been caused by the sonar. I think it was the sonar on the boat.
Sonar mount.
The sonar mount. And that would have been the initial injury. And by the way, that's consistent with expert Stewart's theory on how the bodies moved on this boat. I mean, why isn't Dr. Liu's testimony pretty critical given what you just said?
I disagree. I mean, so who cares if the victim hit the sonar mount versus the pylon? I mean, other than
it says direction. I mean, it establishes the direction that the deceased's body was moving, which would also establish his position on the boat.
But it also doesn't make any sense. I mean, how would the mount still be there? I mean, I would, if he hit it.
Well, counsel, the state didn't offer any experts to go into that. The answer is I don't know. I'm not an engineer.
Well, again, I mean, we're just speculating to a certain extent as to what effect it would have. But I mean, I don't think that was consistent with the evidence that's where, I mean, there was blood on the pylon A and right where those bolts sat out. I mean, I just don't think that would have made a difference, to be honest.
Okay.
I was just seeing if I could see how much, because the victim was like over 200 pounds, as I recall. I was just trying to see where I could find that. But in closing, I mean, if this court has no further questions, I see that my time is about out. I would ask you to rely on the briefs as well as the additional argument I presented today. Thank you.
Thank you, counsel. Okay, counsel for the appellant, looks like you have 4 minutes and 28 seconds in your rebuttal.
Thank you, Your Honor. I would like to rebut a couple of things Ms. Kohler was saying. One, she did say follow the blood, essentially, and she's using this pylon A, but I mean, Christopher Stewart absolutely addresses that. He states that when the initial impact occurred on the stairwell, that Mr. Kadzierski struck his head on the stair rail and then was thrown back to the back right of the boat, where he was kind of hanging off the boat because that's where his blood was found. And then Miss Walker, I guess he was thrown back when Miss Walker was doing the panic acceleration. So they went through the dock, and his testimony was that the evidence lined up that Mr. Kadzierski's head had rubbed or had struck that rail, and then he eventually fell off the boat. So Christopher Stewart,
that would have been after the initial impact and after the panic acceleration, according to Stewart's analysis, correct?
Right. So the state's saying that we didn't explain that. That was absolutely explained by our expert. Now, additionally, a few things. The state said pitch black multiple times. I believe the testimony was that it was dark. I do think that is substantially different than saying pitch black. Additionally, with regard to the blood, the windshield was never tested. Nicole Daniels, the CSI, testified that she was told to not pull any blood off of the windshield, which is kind of unbelievable in the investigation. There was one drop on the steering wheel, and I refute what the state says. It was unrefuted, completely unrefuted. The state actually presented the evidence before we did that Mr. LaPera, once he got up from his being unconscious and was being called over to the shore, he walked over, was bleeding, and drove the boat back to the shore. The state said that's refuted. That is not refuted. That's absolutely a fact that the state actually presented. So, additionally, the state, as the court pointed out, the state did not introduce any sort of accident reconstructionist, but then you have Stuart Stone with this just barrage, and also taking advantage of the lack of presence of Dr. Liu by saying, there's no way these injuries could have caused this. There's no way those injuries could have caused that. That's exactly what Dr. Ling Liu was going to testify to. And he took clear advantage when our witness was not allowed to testify. Additionally, more of a note was Mr. Stone, among the many things, Mr. Ali at the beginning said he needed a blood spatter expert. And at the very end in closing, Stuart Stone states, well, they don't have a blood spatter expert. This is a huge problem because everything the state is arguing, it's really shifting the burden toward us when we're the only ones that, the appellant or the appellant's attorneys at the time were the only ones that were actually presenting evidence of what actually happened. The state's whole case was based on Emily Walker and then a statement that was coupled with I don't remember anything. So their entire case was speculative. And when Mr. Stone is essentially just, for lack of a better word, and I apologize if this word is inappropriate, but just trashing Mr. Stewart. He's doing it based on his own personal opinion. He's not actually including any facts. He's just saying wrong, 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 wrong. And Mr. Ali is being speculative. But the fact is that Mr. Ali, in his argument, stated, I'm not an expert. I'm just relying on the science.
Yeah,
So
real quick on the request for the special instruction.
Right.
This wasn't the biggest issue in my mind, and so I may be misremembering part of this, but once the trial court denied that, and then in closing argument, your position is that the state promised they wouldn't make the argument that your client was guilty just because he was the owner of the boat and present, right? And then your position is that the state kind of broke that promise. You say they did break the promise, and but sort of like they broke that promise and sort of implied it. Didn't counsel for your client need to stand up and say, Your Honor, now we really need this instruction because of what the state just argued? At that point, didn't you need to ask for it again?
I think Judge Rex Fiedler has shown almost an irritation at that point because Mr. Blanker kept saying, I know what he's going to do, Judge. I know what he's going to do. And
but counsel, I understand. And I do understand the difficulty as sort of counsel in that situation. But don't you nevertheless, once the state goes there, after saying they won't, isn't it on counsel to stand up and say, Judge, I'm sorry, but he just did what I thought he was going to do. Now we really need the instruction.
I don't disagree with that, Judge. I will say that Mr. Blanker was vehemently objecting and requesting, and it was shot down. I think at some point he doesn't want to push the envelope and be held in contempt. So
now, I understand. I'm just saying for us to find that to be reversible error, it's a lot more difficult when the state makes the argument you were worried about and there's silence.
Well, Mr. Ali did object once. It wasn't a total non-objection, and I think there are some cases where there's only one objection.
Objected to relevance.
Right, it was relevance, correct. That's right.
All right, well argued, counsel. Thank you for participating today on our law day. And with that, we are adjourned until the next case.
Thank you, Your Honors. Appreciate your time.
Thank you, Your Honor.